Good afternoon, everyone. Thank you so much for being with us today. Asian American Chamber of Commerce is so pleased to collaborate with National ACE to host today's webinar on navigating key legal issues arising from the COVID-19. So my name is Cindy Shao, the president of the Asian American Chamber of Commerce. Before we introduce our sponsor and the speaker, I would like to just quickly recognize our chamber board leadership, also the chamber sponsors who made our events possible. And if you're not a member yet, we encourage you to join us. We are the most active chamber in this metropolitan DC area. And you can just simply sign up membership online. We have a few upcoming events. Our government contracting committee is putting together this event on tech transfer. It's a big event with over 100 attendees. If you're in this area, welcome to join us. And we're going to host another event on PPP, loan forgiveness. This will be held in Chinese language. And our signature event is coming up this October. So we're so excited to have opportunity working with the National Chamber. And next, let's welcome Janet Alec-Paula, the business specialist from National ACE, to give some welcoming remarks. Janet, please.
Thank you, Cindy, for the introduction. Again, my name is Janet Alec-Paula. I'm the business specialist for the Asian Pacific Islander American Chamber of Commerce of Entrepreneurship, otherwise known as National ACE. And our mission is to serve as a strong advocate for Asian American Pacific Islander business interests and affect positive change on all issues that enhance and advance our goals and aspirations of AAPI business owners. As we continue to work with our national network of more than 60 affiliate chambers and partners throughout the country to ensure that AAPI business communities has the most accurate and up-to-date information about federal resources that are available to our community, we're very grateful to the Asian American Chamber of Commerce for having a space like this to host these types of discussions and to have an interactive forum on these very important issues. So now we're just starting to see the data on the impact of COVID-19 that it has had on our AAPI business community. And according to some of the research that we've done and studies by the New York Times, we know that Asian Americans are 1.0 times likely as their white neighbors to contract COVID-19. And based on a recent report by JPMorgan Chase, it shows that balances of Asian-owned businesses declined 22% in April. At the end of March, revenues for AAPI businesses were over 60% lower than they were in the prior year. And overall, Asian American businesses have experienced severe damage to cash revenues and balances that this community is going to require much more assistance than ever from the federal government to fully recover. According to the National Bureau of Economic Research, the number of active business owners in the US has dropped significantly by 22% during lockdown, which was from February to April. However, business ownership in general has dropped 26%. Immigrant businesses have dropped over 36%. So we're seeing so many severe numbers and dropping all across the board. So we know now that targeted interventions are going to be absolutely necessary for small businesses that were hardest hit. And from a policy perspective, National ACE, we're very proud to have strongly advocated for the payment, for the Paycheck Protection Program, Flexibility Act of 2020, which it was a 75-25 expense rule. We've now, it's now at a 60-40 for borrowers, and we've expanded the loan coverage from 8 weeks to 24 weeks. We're also a strong advocate of extending the application deadline for PPP. As of 2 days ago, SBA started accepting applications again for the $130 billion that is now available through this program. And although PPP has not been a super perfect program, we've advocated for modifications so that Asian American Pacific Islander businesses can participate in taking advantage of these funds. So now we're working with Congress to quickly pass legislation that will forgive PPP loans that are less than $150,000 with the completion of a one-page, a simpler version of a forgiveness document. And PPP loans of $150,000 and under account for 85% of the total PPP recipients, but only less than 26% of our PPP loan dollars. Speeding up the forgiveness process for many of these hard-hit businesses will save approximately $7 billion in paperwork and in hours. So we're also advocating for a more robust Minority Business Development Association and to specifically codify this agency into statute in order to make MBDA more permanent. So again, thank you, Cindy. Thank you to the Asian American Chamber of Commerce for having us today on this call. We're very grateful for our partnership. Also with AARP, which is allowing us to give everyone a more up-to-date, more accurate information on to give and share with our national partners throughout the country. So thank you again for the opportunity.
Thank you so much, Janet. Thank you for your wonderful support and to make this event possible. And next, actually, let's welcome our moderator for the event, Isabel Nguyen. Isabel is the board member of the Asian American Chamber of Commerce, and she owns a State Farm agency. So let's welcome Isabel.
Thank you, Cindy. Good afternoon, everyone. My name is Isabel, and as Cindy mentioned, I am a State Farm agent in the Tysons Corner, and happy to be a board member with the Asian American Chamber of Commerce. It is a privilege for me today to moderate today's call on the legal issue arising from the COVID-19 pandemic. I know a lot of you on the call are business owners who are very interested on this topic, and we're very excited to have our guest speaker here today with us. So for the agenda today, we'll go through each of the speakers. You will have an opportunity to submit your questions in the question panel. You can send them in at any time during the call, but we'll collect them and consolidate until the end. And then we'll go ahead and address that at the end of the call. So first and foremost, I'd like to introduce our first guest speaker, Irene Zhang. She is a licensed practice law she has license to practice law in Virginia, Maryland, and DC. Irene's past experience includes positions as a trade attorney at the U.S. Department of Commerce, the U.S. International Trade Commission. She runs her own law practice for the past 10 years. She handled cases in an area of commercial litigations, international trade, and business law. In addition, she's handling trial and appellate matters in the federal and state court. She represents importers and foreign exporter in trade matters before the government. So I would like to welcome Irene to our call today.
Thank you, Isabel. And thank you, Cindy and the Chamber for having me today. And welcome everybody. It's a great opportunity to come and speak with the Chamber and to the Chamber about some recent legal developments. Some are COVID related and some are the timing is concurrent with COVID, but are more directed towards general business matters. The first issue I'm going to talk about is recent developments in Virginia employment law. And part of my practice involves general counseling to small business owners. And of course, with business owners, there are a lot of issues that arise out of employment, independent contractors, basically personnel issues. Cindy, next slide, please. And in fact, this year in Virginia, there's been some sea changes in how employment law is codified in Virginia. And I've picked out two of which I think are pretty significant. It's something that really kind of turns the tide in terms of how Virginia approaches employers and employees. Previously, Virginia, it's been known as more of a business-friendly state, but with these changes, in Virginia employment law seems to be moving more towards the California model, which is very significant for employers. The first new law I'm going to talk about is the prohibition on non-competition clauses for low-wage earners. So for a lot of small businesses, even medium-sized businesses, any businesses, you have a lot of customers. You know, last thing you want to do is have an employee. They're the ones who are customer-facing. You know, they're dealing with the customers. They leave your business and they go and they start another business down the street, and they take all of your clients, customers with them. So a lot of businesses may consider having an employee sign what's called a non-competition or a covenant not to compete agreement, which is a clause that restrains, prohibits, or otherwise restricts an individual's ability to compete with his or her former employer after termination. Well, effective July 1st of this year, July 1st, 2020, there is now prohibition on trying to enforce or require an employee who is a, quote, low-wage employee from entering into such an agreement. Now, the key here is what is considered a low-wage employee? You would think maybe somebody who's making close to minimum wage, $10 or $15 an hour. No, in fact, low-wage employee in the state of Virginia is calculated based on the number shown in Virginia Workers' Compensation Commission. So effective July 1st, 2020, the average weekly wage is $1,137. On an annual basis, that's $59,000 a year. That is what Virginia considers to be a low-wage earner for purposes of this new law. So $60,000 a year may be considered an average wage in Northern Virginia, but you know, that's actually still a, you know, a decently high wage. So a lot of employers, you know, they may be thinking, well, I'll have my middle-level manager sign this covenant not to compete, not realizing that there's now a prohibition on that. And the kicker here is that employees now have a private right of action to sue the employer if the employer requires such a non-competition clause and they're making less than $60,000 a year. Also, the Virginia Department of Labor can fine the employer for violating this law. So, you know, that's pretty serious. Now, there are some caveats to this law. If your employee mainly derives their income from commissions, incentives, or bonuses, that's not included here. Any interns or trainees also would not be covered by that. So if you are mainly a commission-based business and you've got a lot of salespeople working for you, this would not apply. Now, the other interesting development is independent contractor classifications. And I know this, I have clients that come and they want to lower their employee costs, and so they hire people on an independent contractor basis because they don't have to pay them the benefits and the FICA, the tax withholding. But actually effective January 1st of next year, the restrictions on how you classify someone as an independent contractor have increased significantly. Virginia has now basically made employees able to sue. There's now a private right of action to sue for misclassification if they were an independent contractor and they should have been classified as an employee. Also, the state of Virginia can issue fines up to, see here, up to $5,000 if there is a violation of that, if there's a misclassification. And even if you required a worker to enter into an agreement to say they're an independent contractor, if the facts show that they are not an independent contractor, that agreement does not control. So what does it mean to be misclassified as an independent contractor? It's very fact specific. How long has that worker been providing services? If it's more than 6 months, then they're more likely to be considered an employee. Is the work being performed on a full-time basis? I've seen clients who basically they have their whole staff is full of independent contractors, but they're all going to work the same place, working together, shoulder to shoulder, full-time. That would not be considered an independent contractor. Does that worker have an independently established trade or business? Basically meaning, does he or she have other clients, or is your company his or her only client? If that's the case, then more likely to be considered an employee. And is the worker performing work on company premises next to other employees? So again, it's very fact specific, but the stakes and the risks to the employers have increased dramatically. Not only is this a tax issue under IRS guidelines, but an employee can sue for damages, and those damages could include lost compensation, lost benefits, and those lost benefits could mean retirement pay, retirement benefits, and if your company provides medical insurance, say the worker got sick, say for example they got sick with COVID-19, they went to the hospital for 2 weeks, they didn't have insurance, they had substantial medical bills, and it turns out that your company misclassified them as an independent contractor and should have classified them as an employee and given them health insurance. That employee, if they find an attorney, and there are attorneys that will take on cases because these clauses all allow for claims for attorney's fees. They could sue for not only the lost compensation and retirement, they could also sue for the medical bills. So if you really took that issue and really thought, what's the worst case scenario, you can see that the risks have increased dramatically for employees. So I've been advising my clients, go back and take a look at, who have you classified your workers as? Are they employees? Are they independent contractors? Should they be reclassified? And then going forward, when you hire anyone new, you need to be mindful of these new laws. Now, the other legal issue I'm going to talk about briefly are international trade developments. And I've gotten inquiries, and all this material is based on just recent inquiries I've gotten from clients. Because of the shortage of PPE, personal protection equipment, face masks, there are companies that are interested in importing from China. Now the issue is, now because of the sudden rush and the sudden shortage of all of the PPE, now there's a huge increase in substandard and possibly counterfeit products. So someone in the US who's wanting to do that importation and turn around and resell it, they've got to do their due diligence, all right? They've got to do due diligence on both sides, in China and in the US. On the Chinese side, they've got to just check and see, is this a fly-by-night operation, or have they been doing this for a long time? Do they have the proper registrations and certifications? Are they in compliance with what they need to do on the China side? They need to give you all that information before you would take the risk of agreeing to buy from a Chinese entity. On the US side, if that exporter is exporting products that are regulated by the FDA, they need to be registered and they need to be approved. So you need to get on the FDA website, check out these companies, check and see if their registration statement is valid, whether their US addresses and phone numbers all check out. And also whether they've been cited or charged with misbranding or exporting defective products. There actually has been an uptick in those kinds of cases with all this new business of exporting and importing PPE. And also, once you check all that, do the due diligence, you've got to incorporate those risks into the contract. That means putting a detailed contract together to specify what the obligations and requirements are of the Chinese exporter as well as your company. Because if something happens, you've promised to sell the product to a hospital or a government agency and the product turns out to be defective, they're going to come back on you. They're going to come back on you. And you should also put in an inspection period as well as payment in installments to mitigate the risk. So these are some of the issues, and I'm sorry I didn't move the slide over, talking so fast, but if you could move to the final slide. If anybody has any questions, feel free to email me, or I can answer questions at the conclusion. Thank you.
Thank you, Irene, for going over the non-compete and the trade law. I know 10 minutes is not enough to discuss everything, but I'm glad you're on the call today to just give us a high overview of the changes. Again, just a reminder, you can type in your questions for Irene in the question box. We'll go ahead and address that at the end. But if you have direct questions for her, her contact information is on the slide. You can contact her directly. So next, I would like to introduce Mr. Theodore Ted Bostock. He's an extensive and he has a very impressive background. So it will take me the whole call to go through it. So I'll give you a SparkNote version of it. Ted is a corporate and litigation attorney who counsels owners and executives of closely held businesses on successfully starting, running, and selling their companies. He also advised family-owned businesses on succession planning, governance, and assistance in resolving dispute amongst business owners. Ted experience as a former COO and general counsel of a mid-sized family business means he always looks for legal issue in the complex of how they can affect a company bottom line. So today I would like to welcome Ted to the call. Ted, are you there?
Heather, can you unmute yourself? Great.
I'm happy to be here today. Thank you very much. I'm here to talk about mergers and acquisitions. This is a giant field, so 10 minutes is certainly not enough to cover all the issues that relate to mergers and acquisitions and the developments with mergers and acquisitions due to COVID-19. And mergers and acquisitions go across many industries, and every industry has its own problems right now. And so some of what I'm going to say may or may not apply to a specific industry or a specific region. But the biggest issue facing sellers, at least, is the diminution in value of their companies as a result of COVID-19, whether that's due to diminished earnings, diminished sales, or the loss in value of their underlying assets, including questionable accounts receivable that they have on their books because their customers have precarious situations due to COVID-19. All of these together can combine to drastically reduce the value of a company compared to where it was just a few months ago. That makes it a buyer's market. If you're a buyer and you have resources and you have a long view of things, then you are in a good position. You can pick and choose companies that are for sale that fit your needs, and perhaps you can pay a fraction of the price that it would have taken to buy those same companies months before. The only thing is that we are finding there just aren't that many buyers right now who are in that position, who are not adversely affected themselves by COVID-19, and who have deep pockets and a long view on these. Most people are in a wait and see position now, just try to see what's happening in their own industries and the economy in general, because they don't want to commit assets to a purchase that may go bad, or they want to see if the market will go even lower. Judge what the market's going to do, and so there's not a lot of M&A, at least for small companies and mid-sized companies, going on right now. Government contractors right now are in a pretty good situation because many, of course not all, but many government contractors have not been severely affected by COVID-19. their main customer is the government's continuing in business and it's not running out of money. And so their businesses are intact and relatively unharmed. That's not the same for government contractors who do business with state and local governments who are quickly running out of money and are going to have to pare back their purchases, and that will affect many, many businesses around the region. When you go to sell a company, the buyer wants to shift as much risk onto the seller as possible, and vice versa. The buyer doesn't want to risk overpaying for a company that later goes bad, or because of poor management, the buyer just doesn't do as well with the company as the seller once did. So in many cases, the buyers try to offer as part of the consideration for the purchase of a company an earnout, meaning I'll give you a down payment today of X dollars, and then I'll pay you the rest over time based on how well the business does, whether it makes as much profits as we anticipate, whether it did as well as you did in the past. There can be any number of measurements that buyers look to use in order to have earnouts so that the seller gets its money over time and the buyer shifts the risk of what's going to happen in the future to the seller. Of course, that's very, very risky now for the seller because no one knows what's going to happen with many businesses and many industries. So negotiating over earnouts is something that every buyer is going to try to insist on in order to reduce its risk, and sellers are going to try to avoid at all costs. Other concerns that buyers have in today's market are, well, there are many concerns, but just a few that are of great importance that I've encountered recently is real property leases. If you are buying a company that has a commercial lease for office space or industrial space, and the commercial real estate market has gone down, and so the buyer would end up, if it assumed the lease, paying more than a market rate, the buyer wants to, of course, renegotiate the lease with the landlord, and the landlord wanting to preserve its cash flow is going to probably fight that and insist that the buyer assume the lease at the rent that the seller was previously paying. The same is true for equipment leases. Many businesses today lease their equipment instead of buying it outright, and often equipment leases are guaranteed by the owners, especially for small businesses. And if someone is selling a company, they want to rid themselves of the obligations on the leased equipment, which means that the buyer will have to assume those leases. And perhaps those leases, again, just like for real estate, the equipment leases are for amounts that are above market rates, or maybe they're for equipment that is no longer needed by the buyer because the business is reduced from what it formerly was. Another issue that buyers have to look at today are if they're buying the assets of the selling company, are those assets subject to lender's liens, in which case the buyer's not going to be able to get clean title to the assets unless those liens are paid off at the closing on the purchase. And of course, if the price of the company has gone down considerably so that there's not enough money to pay all the lenders off, there will have to be some negotiation over the lender's liens on the underlying assets in order for the buyer to get clean title. Many companies have agreements with their employees in the form of what's called stock appreciation rights, phantom stock, or bonuses to key employees in the event of a sale. If the price of the company has gone down considerably, a lot of these are fixed amounts and therefore have to be paid off at the closing before the seller realizes anything from the sale. And this is an issue sometimes where the seller ends up with, as a percentage, a lot less of the company than he or she thought he was getting because the costs involved in paying in these obligations that were incurred when times were much better have to be paid off. Another issue that we have recently come across is when a seller goes to sell his company, the buyer normally asks the seller to make what's called representations and warranties about the condition of the company, about its past performance, about a whole range of issues, so that the buyer's in effect asking the seller to ensure that certain facts are what they seem, that things are not going to change, and that the buyer can be assured that what he's buying is what he thinks he's buying. With COVID-19 has put so much uncertainty into various businesses that we're now seeing buyers insist on representations that, one, the business has not suffered due to COVID-19, the seller is not expecting any adverse results on its business from COVID-19, and a lot of this they can't make, in which case the seller can't make those representations and warranties, and the buyer will then insist on a lower price to make up for the uncertainty that the seller can't make any guarantees about. I'd like, given my shortage of time, I'd like to move into the other topic I was to address today, and that was a business divorce. And that's sort of related to mergers and acquisitions, because just as financial problems can often force people to sell their companies for one reason or another, it often contributes to a breakdown in relations between owners of the company. And instead of selling, perhaps there is a business divorce where the company splits up, one owner takes part of the business, another owner takes another part, or an owner is bought out because the partners can no longer keep the business together as they once did. When economic conditions deteriorate, most businesses try to cut their expenses, cut their payrolls, or whatever they can do. What happens when the expense you want to cut is one of your minor partners? That becomes a big issue for companies, particularly if there's no agreement in place about forcing minority owners to sell their minority interest in the company. What happens if a minority owner, or any owner, could be a majority too, has a right to retire and get bought out, and the company's value has gone down considerably because of the current economic situation, but someone exercises his right for early retirement, leaves the company, and demands that the company buy back his equity interest. And maybe the company can't afford it anymore, and it creates a lot of problems. There are ways to get rid of minority stock owners in a company if they are also working there and the company can no longer afford to pay them all. There are a whole variety of mechanisms that have been developed by people, by lawyers mostly, for business divorces, to force some owners out, or to force some owners to take part of the company and separate from the main company. And there are various names for these things: spin-offs, split-ups, split-offs. Each one is a variation on a transaction where some of the owners split off or split up from the main company and go their own way, or forced to do that. There are some agreements among owners where we have something called a Russian roulette provision, where the parties know that one wants to get out or wants to force the other out, and there's a mechanism in place so that one owner offers the other a certain purchase price, and the person who receives that offer has the option to either accept it or to force the offerer to accept it, so that there's an incentive not to offer a small amount of money. But we see people have entered into this type of agreement and are exercising their rights under it.
So Ted, thank you so much for sharing your experience and background with M&A and business divorce. As I mentioned earlier, you have a lot of knowledge and wisdom. I bet, you know, we can spend a whole call on your topic, but due to time, we're gonna have to move forward to the next speaker. Again, if anyone have any questions, feel free to type it into the question panel for Ted. He'll answer that toward the end of the call. Thank you so much. Thank you. So next, I would like to introduce you to Ms. Ming-Sing Esther Kui. I personally know her and I've worked with her because she advised me on various different occasions, but Esther is an attorney at law at Junk LLC, Virginia office. She received legal training both in China and in the US. She is multilingual. She speaks English, Mandarin, and Taiwanese. Esther earned her bachelor's degree at international law from Northwest University of Politics and Law in China. During her college year, Esther took an internship at Wickwang Rain and Company, an international law firm that located in Shanghai. After 4 years of studying law in China, she furthered her study in William and Mary Law School here in Virginia, where she earned her JD degree. Esther has been and remain active in spreading public legal education and legal awareness by giving presentations to minority group. Now, as an attorney, she practices law and gained various experience from different areas, include operations, corporation, litigations, family, immigrations. So let's welcome Esther to the call today.
Thank you, Isabel. Thank you, Pat, for the awesome presentation. So I'm gonna take it from here. So just a brief introduce myself. I'm an attorney and I work in Reston office in Virginia. So I practice in Virginia from Chub Law Firm. I'm really glad that I can give a very brief introduction about the debt collection and how the attorney plays their role in this matter. Because I believe it's really important, especially for this period. I believe it can be a very tough one and a tough thing for the small business owner especially. So let's go to the next slide and let me start with the first thing, because every client, when he comes or she comes to me, and the first question I always ask is, what do you want? So it's not every case can be filed in the court. Definitely you can, but there's some valid, defense for it, which we call, one of them is statute of limitation. So what is statute of limitation? The purpose behind it is to ask everybody not to sleep on the rights they have. So if you realize the opposing party has breached a contract, for example, they fail to pay you when you send invoices, so then you should initiate either sending a demand letter or start a file in a court. So the statute of limitation is a specific period, allow people to file their case in the court. So however, if the time collapse and for example, in Virginia, if you didn't do anything when you figure out there's a breach of contract, 5 years later, you cannot bring the case again in the court because it's out of the time. So again, it's based on different state. It's from state to state. For example, in Virginia, it's for 5 years for a written contract and 3 years for an oral contract. But compared to Maryland, it's for 3 years of breach of contract. So every time if you figure out there is a breach of contract, definitely you need to consider how to pursue your right. So the next slide, I would like to discuss about what to prepare. Because when you want to pursue and protect your right, it's very important to understand what's your burden in front of judge or even before the court, what you have to prepare. So let me give you a scenario. One of my clients comes to me and he is an IT company So the company is providing consultant service to vendor, which means that they assign their own employee to a vendor. The vendor will, place that employee to the vendor's client, which we call an end client. So basically, you can see there are two layers here. So what to prepare in that scenario, actually it's very common. The first thing is definitely an executed contract. I believe as common knowledge for business owner, the contract must be valid, which means executed by both parties. And if there's any invoices, you definitely should keep it. So for example, in the scenario, in the contract, probably as per the contract, it specifically said, the company has to send invoices within how many days, then you definitely need to comply with that. So the invoices should be kept. Another one is email exchange between the parties. The reason why I ask this is because sometimes there's no point of contact. So the contract is directly signed online. So there's no in-person relationship. And once you send email to the opposing party, they sign and give it back, and that's it. So you send the people to work for them or you provide service. But there's no closer relationship between the parties. Because of that, the email exchange will be more important. The reason is, for example, one of my clients, definitely he doesn't have any person, to contact. The only thing he has the evidence and the contract. So the email he back and forth, there's one email sent from the opposing party say, due to the internal issue and COVID-19, we are not able to, to make this payment until how many days. So basically, this email is really important because which shows the opposing party admits that they own the debt and they ask for extension of the time. So that's the reason the evidence like emails can be a very circumstantial evidence to provide. The last two things I would like to discuss is the timesheet and the statement of work. So the statement of work is one exhibit attached to the agreement. So what is it? The statement of work specifies the duration, the time, and the person who does the who does the service, and also for the hourly rate or any fee, either flat fee or hourly rate, will be specified in the statement of work. So if you have it with the contract, don't forget about it. Just keep it for the potential litigation or for potential negotiation. So the next step, definitely I would like to introduce is what we're gonna do after we collect all this kind of evidence. So how we pursue our goal and how we get money from the opposing party. So definitely the first thing is sending a demand letter. So a lot of my client actually asks me why I need to send a demand letter, because opposing party definitely is aware of the breach of contract. They never replied me why I should spend like this money and waste time to send a demand letter. So the first is demand letter is sent by attorney, normally in a typical case. And actually the purpose behind it is the first, trying to figure out whether there's any opportunity to get a settlement. Definitely there were some back and forth there, but also the purpose is to convey a message to the opposing party, like a company told them an attorney has been involved. So we are taking it very seriously to go to the court to get what we should get. So the demand letter's purpose is this. The second is I would like to always let my client know about the settlement, because the settlement is the common thing. So according to the investigation, 95% of the cases will be solved and settled in front or before the court even go to the trial. Why? Because the first, my client, always ask how much I should get, how much I can get. Actually, it's a very important question, and it's the essence of business. So including the attorney's fee and the litigation and the filing fee, hourly rate, this is all the cost from our client. So why they need to spend this money if they can get a settlement? So although probably they should give up like 20% or 15%, but also it's still, a more effective and cheaper way to pursue the right. So that's the reason the settlement is really important. But however, there's always some very worst scenario that nobody respond and nobody, there's no back and forth, no settlement, no negotiation, nothing. So in that case, definitely you have to pursue a right as the clock is ticking. So what you should do is you file a complaint. So for this complaint, definitely it's pretty easy and it's very straightforward. It also depends on how much money you are claiming. So for example, for the general district court, definitely there will be a much lower bar. Any money claimed under like 25,000 probably will go to the general district court. But any money higher than that, for example, I had a client who claimed 70,000 or even 90,000. So in that case, the circuit court will take the case. So file a complaint is the first initial step. And if you get any response, that will be better, which means that you get an opportunity to settle it. But if not, definitely you have to serve the defendant by either the private server or sheriff. So when they serve the defendant, they have a specific time to respond to your complaint, either admit or deny. In the best case, if they didn't do anything and they missed the deadline, so definitely you can file a motion for the ask a judge to get a judgment against them. However, if both party has dispute as to the contract and show up in front of the court, so the judge will set up a trial day. So before the trial day will be a time for everybody to exchange the evidence, and they still have a lot of time to make a negotiation and to make the settlement. So, however, if nothing happened, then the final one is the trial. So the trial is like a normal procedure. Each party provide their exhibits and evidence to show either I breached the contract or not, or how much I paid. But most of the case, my client solved it before they really filed the case. So after that, it's a judgment enforcement. So what does that mean? That when you win the case, you finally get the judgment from judge. So what you need to do next is to enforce the judgment. So because of that, you have to file another separate document, request a writ of position. So the judge will give you authority to attach the opposing party's wage and income. So in that case, you can get money from them. So I hope everybody is not going to go through this procedure, and hope everybody can get things settled smoothly. And thank you so much. I think that's my part. Thank you.
Thank you, Esther, so much for sharing about debt collections. More comfortable now going to you if I ever need this service. But next, I would like to introduce Cheryl Lemel, who is a partner at Dublin, Bennett and Lockwood, a veteran-owned law firm in the local presence and global knowledge that boasts over 75 attorneys who are licensed to practice in over 40 states and multiple countries outside of the US. They have successfully handled a wide range of matters for individuals, entrepreneurs, small business, Fortune 500 companies, and sovereign governments. Their practice include business information, M&A, trust, estate planning, cybersecurity, immigration, insurance, intellectual property, to name a few. Welcome to the call, Cheryl.
Well, thank you so much, Isabel. I really appreciate it. Well, it's such a pleasure to represent not only Dunlop, Bennett, and Ludwig, but the great Asian American Chamber of Commerce Board. I just joined the board, and I am privileged and honored to be here on their behalf. That said, if I look like a bus hit me, it's because I'm an immigration lawyer under COVID-19. For many of you who've been following the press, immigration has been a hot topic since COVID-19 hit, and we in the field are certainly feeling it. That said, so what I'm going to do today is talk a little bit about the work visas. I know one of the big issues that happened yesterday had to do with student visas, the F1s. We've been talking about that so much for the last week. I'd be more than happy to discuss this with anybody offline or at any other time, but I'm going to focus right now on work visas. I'm going to start with the most popular work visa, temporary work visa, which is the H1b program, and talk a little bit about the impact of COVID. So the H1b program applies to employers seeking to hire immigrants as workers in specialty occupations. So specialty occupations are occupations that require specialized knowledge, generally attained through a bachelor's degree. This is one of the key items that you have to prove in order to successfully obtain an H1b visa. The job description must on its face say that this is a specialty occupation, and simply saying that a bachelor's degree is required is not enough. That'll be rejected summarily. Obviously the beneficiary would have to be qualified for the specialty occupation, and then the company has to pay the prevailing wage. The prevailing wage is determined by a database held by the Department of Labor. And the first step in the H1b process is to apply to the Department of Labor for a determination on the prevailing wage. What is typically done is you provide your job description, you identify the job title within the database, you see what the prevailing wage is, and then you ask for certification that you are paying higher at the prevailing wage or higher. This is a tremendous problem right now. Well, all of the panelists have mentioned already how the diminished value of many companies. Obviously, the pandemic has hurt many companies. For those who hire prevailing wages, hire H1B employees, this is particularly painful because now you have to make a decision. You have a certified LCA that says you're going to pay a certain rate and for a full-time job. If that changes in any way, it has implications. If you lay that employee off, you have to actually withdraw the LCA. You have to go through the formal step of withdrawing because this person is no longer meeting the requirements of the LCA. If they are furloughed, you then have to apply for an amended LCA. And it's not always clear that that would be approved. Even though DOL recognizes that because times have changed, because profits have hurt, that many companies have to make these difficult decisions. Quite frankly, the climate right now for approving amended LCAs is not very good, in part because there is a general philosophy to try to rid the country of as many temporary immigrants as they can. So this is certainly a major problem, but if this is an issue for you, I'd be happy to discuss the implications here. It's important to know that the way the H1B program has historically worked is you apply 1 day a year, that's April 1st. So you obtain the LCA, which generally takes about 7 days. You obtain the LCA, and once you have that, and once you have the paperwork from the client, you submit, everybody submits on 1 day, that's April 1st, and then the USCIS would host a lottery because they generally get about 250,000 petitions. They host a lottery to whittle it down to about 110 or so thousand petitions, and then they select the 85 that is the cap as mandated by Congress. They take 85,000 H1Bs. Under the H1B program, if you are selected for an H1B, your first H1B, you cannot start until October 1st. Everyone can start anytime after October 1st, but you cannot start until October 1st. So if you're selected historically you were selected in after a month or a month and a half in May, June, then you would be covered in terms of being able to stay in the United States for the balance of the summer until October 1st, and then you would start October 1st. The presidential proclamation on June 4th raises the second concern for many who have H1b employees, and that is that the proclamation said that as of June 24th, the United States will not accept any H1b students from overseas until 2021. So this means a lot of companies that have consistently and constantly depended on employees starting in the H1b process on October 1st now have to wait until 2021. Now, one of the things to make clear, if your H1b or prospective H1b employee is here in the United States, he or she can start on October 1st. If they are outside, however, they have to wait. We don't know. You know, it's possible that the entry of H1Bs could be delayed further. It could be delayed further because of the pandemic. It could be delayed further because of government decision. But this puts a lot of companies in a bind as far as, you know, how they plan to meet their employment needs in the balance of this year and going into next, particularly with government contracts that start at a specific time. The presidential proclamation banning H1Bs, L1s, H2Bs, and J1s on the 24th has obviously was a bit controversial. We know that there's going to be delays based on the pandemic, so why these extra proclamations is certainly of concern. However, I'm going to just talk a little bit about one of the most controversial aspects of it, and that is with the L1 visa. The L1 visa is an intercompany transfer. So if a company is either in the United States or overseas, and they have a branch or a subsidiary or a parent located in another country, executives in the company can decide for strategic reasons to place an individual overseas into the U.S. branch. They could bring them for reasons related to their skill set or their talents to actually manage here in the United States, because it's only available to executives or managers. The challenge here is the justification for the ban on L1s has been that the L1 visas and H1Bs and H2Bs are taking U.S. jobs away. Well, the problem with that logic is L1 visa holders already have a job. They already work for the company. So coming to the United States, they're not taking somebody's job. They're just doing their own job. They're doing the job they already have, but they're coming to the United States to do it. And the whole purpose behind this, the reason Congress created the L1 visa is because they wanted to encourage companies, particularly larger companies overseas, to build branches in the United States to create more jobs. And this has certainly been a very effective way of doing it and contributing to the U.S. economy. But it's still, there is a ban now on L1 transfers. There's a strong possibility that this is, I know this is going to be challenged. Now, whether they're going to overcome the challenge as they did with the F1 program yesterday, I don't know. But I know it's going to be challenged because you're talking about really interfering with the autonomy of executives at large corporations to strategically place their own staff. And this isn't hiring someone new, this is someone who already works for them. So, now, in the midst of all that bad news, I should say, are non-immigrants on temporary visas, can they still be admitted? Yes. So anyone on a B1 or B2, an E1 or E2, an F1, an H1b, L1, O1, P1, and TN visa, who are overseas can still come to the United States as long as you're on a valid visa. Now, there may be issues related to pandemic travel, but as far as the proclamation, it does not impact those who are already on visas. There are also a couple of other visas that we do work on at the firm that have not been affected by any proclamation. One is the E2 Investor Treaty Visa. There are about 60 countries that have treaties with the United States for investment purposes. And the E2 investment treaty investor visa allows investors to live and work in the United States to direct and develop a business that they started, and also allows executives and managers to come to the United States to work in that company. E2 visa, you may have heard of the EB5 visa. This is different from the EB5 in the sense that the E2 is a non-immigrant visa. And there are no requirements with regard to hiring. You don't have to hire 10 citizens like the EB5 program, nor do you have to, is there an investment limit? You can invest as little as $20,000, $25,000. However, if you invest under $200,000, you're certainly going to have a very difficult time getting an E2 visa. You really have to demonstrate that you are going to not only develop a viable company that's going to pay your salary, but will eventually pay the salaries of a number of other people, including U.S. citizens. So the most important aspect of an E2 visa is the business plan. The business plan is going to be key because that will show that this is a viable company that has a future, that is going to contribute to the economy, and there is good reason to bring this investment to the United States. The last reason, yeah, please.
Oh, sorry to interrupt. Yes, we are running out of time at 3:03. I know we're 3 minutes past, and there's more that you like to share. Yeah, I know everyone's on the call. We have a few questions in the chat room. I would like to address that, if you don't mind, Gerald.
Please.
So I know we're 3 minutes past, but if you'd like to stay on, you're more than welcome to. This webinar is being recorded, so you'll be able to have access to this later. There are a couple questions out there. One is from Dino. I believe this is to Irene. So what exactly define independent consultant if an independent consultant work normal hours like a normal employee?
Independent consultant, I don't know if Dino is referring to independent contractor, but it's really fact-based whether or not an independent contractor should be classified as an employee. So if this independent contractor is going to the office 9 to 5, just like the employees of the company, they're working full-time there, just like the employees, and this goes on for more than a couple months, then probably that person or that worker should be classified as an employee. The guidance on what constitutes an independent contractor is really, does that independent contractor have his or her own separate business? Like there may be some IT professionals that sort of sell their services to several companies at once, and that IT person may have a website and have several regular clients. And so they may go to one site for a few hours and then go to another site for another few hours. And so that type of worker may be more, properly classified as an independent contractor. But if you have somebody that's going to work regularly, working shoulder to shoulder with the employees at the office, and it's a full-time job, even if they're getting a 1099 or even if the employer is issuing a 1099, the IRS and the Department of Labor in Virginia may consider that to really be, that person really should be reclassified as an employee. And that employer also runs the risk that worker later may come back, may find an attorney, will come back and sue the employer for damages arising out of the misclassification. And they can't contract their way out of it either. A contract between the independent contractor and the company may be one piece of evidence to show that they were properly classified, but it's not determinative. So it just really depends. It's a fact-specific analysis. And I think to Dino, I think if they're working normal hours like a normal employee, and if this is going on for more than a couple months, then it sounds like they're more like a employee.
Great, thank you. The next question is from Anne. She's asking, do you recommend having employees to sign a COVID-19 liability waiver before to return to work?
I think, and I've seen this actually, this question asked about from clients regarding, if they have like a business or they have, clientele that are coming back into a salon or something like that. They're concerned that the customer, if the customer catches COVID, that they may go after the business. For employees, it really depends. I think the law is not clear at all on this, whether that COVID-19 waiver is even enforceable. Because say an employee signs it and later gets infected with COVID, can the employer really, hold that waiver up in court and say, well, the employee waived her rights? It's not clear right now because the law is obviously not decided on this issue. And it also might send the wrong message to employees. They may not want to come back to work if they think that the employer is just saying, well, I'm going to have you waive your rights and I'm not taking steps to make sure that the workplace is safe, or that I've complied with all the OSHA regulations, all the state, local mandates on keeping a workplace safe. So at this point, I would say the law is not clear whether that's enforceable, and it's really a business decision about whether you want to do that for your employees. Right now, I've had clients tell me that they even have a hard time bringing some employees back because they're just worried and they don't want to come back. So now may or may not be the time to do that.
Great, thank you. I think the next question is from one of my customers. It's for Ted. This is relating to COVID-19 and business. He runs a restaurant, multiple restaurants, and he has different corporations under each restaurant. If he filed for bankruptcy, would this impact his personal credit?
The bankruptcy filing for the corporations would not affect the credit of the stockholders or members of the companies. The only problem is if he personally guaranteed certain debts and obligations of the corporation, the bankruptcy filings of those corporations does not relieve him of those obligations. They all may come back to him, in which case his personal credit could be jeopardized because of the actions of the creditors trying to collect on what used to be corporate debts.
Okay, just a follow-up question on that in terms of leasing agreement under corporations. If they break that contract, would that fall under the corporation or it follows the owner?
Well, it all depends on what the lease says. If the lease is simply with the corporation folds or declares bankruptcy, then any liability coming from the termination of that lease will not affect the owner of the company unless the owner also personally guaranteed the obligations under the lease, in which case the landlord will have the option of suing the owner for whatever rent that remains unpaid, or whatever obligations that the company would have been entitled or obligated to.
Great, thank you. So I think that's all the questions we have for today. If anyone have questions for our guest speakers today, feel free to, you can reach out to them directly, or you can channel that through us and we can get that questions to our guest speaker today. Again, thank you so much for being on the call today. We value each of your expertise today on the call. This has been a very meaningful call. So thank you again.
Thank you.
You.
Thank you.
Guys. All right.
Thank you, everyone.